Hi everyone, let's talk dormant commerce here, and we'll start as always talking about what red flag facts you're looking for that would trigger a dormant commerce clause analysis. Unlike the straight up commerce clause analysis, which is triggered when Congress does something, dormant commerce analysis is triggered when a state does something or a subdivision of a state city. So to repeat, it is so critical in identifying issues in constitutional law questions, which government is doing the acting. So first of all, dormant commerce is triggered again when the state does something, a state does something. Now, on a con law bar exam essay question, when a state is doing something, whether it's the state of Florida or state A or whatever you want, whatever the case may be, there are all kinds of issues that might be in play. So what I want you to do is when somebody is challenging a state, check whether it's a rights-based type of a question or a state authority generally type of a question. In other words, bar examiners could have a state violating the First Amendment. They could have a state violating the Equal Protection Clause. More on those things later. They could have a state violating due process rights. So if it's one of those things, then that's not a dormant commerce question. Dormant commerce tends to arise not when the challenger is saying, "Oh, the state violated my rights in some way, or my equality, right? The equality principle in some way," but when there's a general claim that the state lacks the authority to do something. Normally, when somebody claims that the state lacks the authority to do something, what they're saying is that that's supposed to be the federal government doing that, not a state. That triggers a dormant commerce analysis. To confirm it's a dormant commerce analysis, look to the state doing something that has some kind of an economic impact, right? That interferes somehow with commercial activity or the economy. So those are your red flags for issue spotting. It's a state. You don't see some kind of rights-based claim, you may see overlapping. And in fact, there was a recent question where the bar examiners had the state of Florida banning advertising of, I think it was citrus, from out-of-state growers. And so there you're going to have a hybrid. So I'm not saying one excludes the other. I'm just saying look which is in play and talk about whichever one is in play. One of the claims in that in that question that I just gave you, one of the issues there was First Amendment, because when you target advertising, recall that's commercial speech. But there was also an economic impact, right, of a state doing something that affected out-of-staters. So you have to be attuned to these things. So you might have an overlap, but the dormant commerce part of the analysis is not the rights part. So look at the fact pattern, decide whether a state is acting. If there's some kind of general claim that the state lacks the authority to do something, particularly because that something affects the economy or commerce, make sure you include a dormant commerce analysis. Okay, let's talk text. In a dormant commerce case, you would always cite the 10th Amendment or a dormant commerce fact pattern, because the 10th Amendment obviously is the source of state power to regulate for the health, safety, and general welfare of the population. So you would cite that. You would also cite the Commerce Clause in Article 1, Section 8, because there is here's the way courts put it. There is a positive and a negative aspect of the Commerce Clause, and in an affirmative way, I should say. The Commerce Clause grants power to Congress. The flip side of that is that it is understood to limit the authority of states to interfere in interstate commerce. So that's your text. It's the 10th Amendment and Article 1, Section 8. When you're starting your analysis, put the sentence in there. States have concurrent, to some extent, jurisdiction over commerce, right? Because you're not going to have a court saying that states can't do anything that affects interstate commerce. There'd be nothing left for states to do. So use that magic language, concurrent jurisdiction. However, there are rules for determining when a state has gone too far. Okay, now you get to the actual analysis. The threshold question in a dormant commerce case is whether the law discriminates against interstate commerce. Define discriminate in this context. That means to erect barriers to trade, stop things or people from going out or coming in. That certainly is something that you could expect on a bar exam soon, given current events of the stoppage of interstate traffic. So that's one definition, is erects barriers to trade. The other definition is treats in-state and out-of-state private business interests differently. Remember that this is this video is too general to get into these weeds too much, but I want you to remember that a state is allowed to discriminate in favor of itself. It's not supposed to be discriminating in favor of in-state private business interests. That's protectionism, and that's the evil that is sought to be addressed by dormant commerce principles. Furthermore, the state is allowed to participate in a marketplace and discriminate that way if the state is discriminating with regard to the market it's actually in. So keep those nuances in mind. But generally speaking, the threshold question, once you get past citing the text, is does the law discriminate? Define it. Again, that means erect barriers to trade or treat in-state and out-of-state business interests differently. If the law does that, you apply strict scrutiny, and you should know how to do that by now. You look for whether the means are narrowly tailored to the achievement of a compelling interest. Narrowly tailored, when you're doing that analysis, please use words like under-inclusive or over-inclusive. That's what you're looking for, because if a law is under-inclusive or over-inclusive or over-broad or sweeps too broadly generally, that's the definition of not being narrowly tailored. And you remember save the children, right? When you're looking for a compelling interest, it doesn't literally have to be save the children, but compelling interests are generally thought to be those involving health and safety, right, of the population. So that's strict scrutiny. Now, if the law does not discriminate, here again the magic words, but has an incidental impact on interstate commerce, then you apply the Pike test, right? And you would identify that as a balancing test that goes like this. A court will uphold a law under Pike unless the burden placed on interstate commerce is clearly excessive in relation to the putative local benefit. And so there you're going to do a balancing test, but remember that scale, if you will, is weighted in favor of the state. So that is how you do a dormant commerce analysis. One more thing. It's possible when you see a dormant commerce type of fact pattern that it also involves the Privileges and Immunities Clause of Article 4. Be on the lookout for some kind of discrimination that goes to the fundamental rights involved in citizenship, like moving to another state, acquiring a job in another state, working in another state, acquiring property in another state, establishing domicile in another state. Those things are called fundamental rights under the Privileges and Immunities Clause. And you have a similar test here. It's a means ends test. That's pretty challenging for the state. That kind of, when I say similar, kind of like strict scrutiny. It's not quite strict scrutiny though. It's more intermediate, where the state would have to show that the means are significantly related, substantially related, closely tailored to some important interest, some significant governmental interest. So the P&I clause, again, if you see something like state barring interstate travel, barring people from coming into the state to work, barring people from establishing domicile or obtaining property, those things would be fundamental rights that would also trigger a quick P&I privileges and immunities analysis. Remember that we're talking here about the P&I clause of Article 4, please, right? The 14th Amendment P&I clause is a nullity. I mean, I'm overstating it there, but there's very, very little that is protected under the 14th Amendment's P&I clause. So make sure you know which one you're citing. Okay, so you got a state interfering with something economic. Make sure you think about dormant commerce, and you might have a P&I issue as well. Hope that helps. We'll be back with more videos, a couple more videos to talk about individual rights.